According to legend, Abraham Lincoln once asked rhetorically, if you call the tail of a dog a leg, how many legs does it have? Answering his own question, he then said 4. Because even if you call the tail of a dog a leg, it still has 4 legs. It doesn't become a leg simply because you give it that name. This is a baby. This is a human. It has fingers. It has toes. It is, by any metric, it is by any casual observation, a human in form and in substance. The fact that this baby has yet to take her first breath doesn't deny her humanity. Bad things happen when we deny the humanity of human beings. Our history books are littered with disastrous, tragic consequences that stem from any decision to call a human being something less than human. Now, I understand that many Americans, including, I suspect, many in this room, might disagree as to the exact moment when this child should be deserving of protection under the law. In fact, what one state might choose to do to protect unborn human life might differ from that of another state. In 1973, some 48 years ago, the Supreme Court of the United States decided to take some of these otherwise debatable matters beyond debate. First, by denying the personhood, denying the existence of a human being, but then, on top of that, grafting onto the Constitution something that is not there. Now, I've read this document, the United States Constitution, which they purported to be interpreting when they decided that case. I'd challenge anyone to identify what provision makes this a person who can't be protected under state law. That is, make no mistake, effectively what the Supreme Court of the United States was doing. First in Roe versus Wade in 1973, and then in Casey versus Planned Parenthood in 1992. Roe versus Wade was only 19 years old at the time Casey versus Planned Parenthood was decided. At that time, the Supreme Court of the United States declared, albeit through a highly fractured Supreme Court opinion, one that couldn't even and didn't even garner a single focal point majority, a plurality opinion, declared the debate over whether the Constitution takes this debatable matter beyond debate as closed, as finished, as done. But you can't take something that isn't protected by the Constitution, putting it on par with the right to free speech, the right to be free from unreasonable searches and seizures, freedom of religion, and so forth, something that's completely untethered from the text, the historic understanding of the Constitution, and call it a constitutional protection. When you do that, you do violence to the constitutional structure itself and to human beings. Now, make no mistake, Casey didn't resolve anything. It only compounded the error. Because when you start with something that isn't found in the Constitution, you try to tether it to the Constitution, you make things up along the way. You make things up that are themselves incapable of amounting to a judicially manageable standard. Now, some would argue we've got to stick with Roe and Casey because of stare decisis, the idea that the Supreme Court follows its own precedent. The principle of stare decisis is not an inexorable command. Far from it. It's one that acknowledges that there are times when the court has strayed so badly from the text it purported to interpret that it's not sustainable. That is particularly the case where you have a standard that's offered no sense of certainty to the lower courts, has proven to be judicially unmanageable, has led to multifarious and inconsistent interpretations of the same principle, ostensibly, of federal constitutional law. So to be very clear, in addition to the fact that this is a person, in addition to the fact that 80% of Americans agree that it is a person, and as such should receive protections, this case isn't one in which the Supreme Court is charged with deciding to prohibit, ban, decriminalize and otherwise outlaw every abortion in the United States. That's not on the table. That's not the issue. The issue is whether the people, through their elected representatives, should be able to decide how to protect human life and the life of mothers in the manner they deem fit. The Constitution, nature, and science all indicate that that is a right that the people have, not one that belongs to 9 lawyers in robes.